Ruth Pemberton signed the deed in lieu of foreclosure on a Tuesday morning in March. She drove home on county roads she had driven for 22 years, past fields she recognized by their drainage patterns and their soil colors, and she allowed herself to think that the worst part was finally finished. She had 120 dairy cows to disperse, equipment to sell, and an empty barn to sit with for as long as it took. But the farm was no longer hers, and the debt that had been eating through everything since 1984 would no longer be her problem. She had given the bank the land. The bank would sell it. Whatever came out of that sale would settle the account. She was 54 years old and she was starting over. That was what she understood had happened. The registered letter arrived 6 weeks later. Ruth had been dairying in Dunn County, Wisconsin, since 1965, when she and her husband Vernon had purchased the farm together. 240 acres, a 40-stanchion barn, and the milking equipment that came with the place. They had expanded the herd over 20 years, eventually running 120 cows through 2 milkings a day, selling to a cheese cooperative that paid on a component basis and had been a reliable buyer through most of that period. Vernon died in January 1984. The heart attack came without warning on a February morning when he was checking on a heifer that had calved during the night. Ruth was in the house when she heard the dog barking at something that wasn't moving. She had kept the operation running. She hired one full-time hand, a young man from Boyceville who knew dairy cattle and was willing to work for what she could pay. The two of them ran the 120-cow milking operation through 1984 and 1985, twice a day, 7 days a week, the same schedule the farm had run on for 2 decades. The cows did not know Vernon was gone. The milk cooperative's tank truck came on its schedule. Ruth learned the books because she had to. She found that Vernon had been a careful record keeper, meticulous in his columns, and she could read what had been happening well enough once she took the time to look. What she read was that the operation had been running at a loss since 1982. Milk prices had softened as government support programs adjusted downward. Feed costs had risen. The operating note had been drawn to cover the gap each year, and the draw had been larger than the repayment because the dairy revenue was not quite enough to close the full operating cycle. Vernon had known this and had been managing it forward, expecting prices to improve, buying time with the credit line the way a careful man might. Not recklessly, but not comfortably either. Ruth had not known the specific numbers because she had not been managing them. She had been managing the animals. By the end of 1984, the operating note stood at $167,000. By the end of 1985, with another year of draws and partial repayments, it had grown to $189,000. The land mortgage, originally $120,000 in 1972, when they had expanded the barn, carried a balance of $84,000 after 15 years of payments. Equipment debt added another $26,000. The bulk of it on a new milking parlor installation they had financed in 1980. Total obligations, $299,000 heading into 1986. Ruth approached First Wisconsin in the spring of 1986 to discuss a restructuring. The loan officer, a man named Bremer who had held the farm's account since the early 1970s, reviewed the financial statements with her over 2 meetings. He was not unkind. He was direct in the way that people are when they have worked with an account for a long time and know that directness is more useful than softening. The numbers did not support continued credit extension. Milk prices had not recovered. The land's appraised value had fallen from $312,000 in 1982 to $208,000 by Bremer's most recent review. The equity margin that had provided comfort in earlier years had effectively disappeared. Through the summer and fall of 1986, Ruth managed the operation on reduced credit while she and Bremer worked through the options. She dispersed 40 cows from the herd to reduce feed costs and operating load. She sold 2 tractors she could do without. She made partial payments on the operating note whenever the milk check allowed. By November, Bremer had moved the account to the bank's Agricultural Resolution Department. The resolution officer's name was Haas. Haas had a procedure. The procedure was deed in lieu of foreclosure. Ruth would transfer title to the property voluntarily. This avoided the cost and public timeline of a formal judicial foreclosure, which would have required court filing, legal notices, a sheriff's sale scheduling period, and attorney fees on both sides that would come out of whatever the property eventually brought. A voluntary transfer was cleaner and faster. The bank preferred it. It saved everyone the formal process. In exchange for Ruth's cooperation with the voluntary transfer, Haas explained the bank would limit its pursuit of any remaining balance to the standard deficiency process under Wisconsin law. Ruth heard limit its pursuit and understood it to mean the bank was being reasonable about what it expected to recover. What it meant, in Haas's careful legal phrasing, was that the bank was preserving its right to pursue a deficiency judgment through the standard statutory process, which was exactly what it then did 6 weeks after Ruth drove home from the signing. She had signed the deed in lieu on that Tuesday morning in March 1987. She had not asked Haas to define standard deficiency process. She had not known she needed to. The attorney who witnessed the signing had reviewed the transfer documents, but had not explained the personal liability implications in terms that landed with sufficient clarity against everything else Ruth was managing that day. The herd dispersal, the equipment decisions, the question of where she was going to live once the farm changed hands. The bank scheduled the property for a sheriff's sale auction. The auction produced $118,000. This was not a surprise to anyone who had been watching Wisconsin farm auction prices in 1987. Agricultural land was moving at levels that reflected the distress of sellers more than the productive value of the ground. Buyers were cautious. Investors who had been aggressive in 1981 had been burned and were staying back. A 240-acre dairy property with a barn requiring significant maintenance and a milking system that was 15 years old attracted limited bidding. The high offer from a neighbor who wanted to expand his crop acres but had no use for the dairy infrastructure came in at $118,000. Ruth owed $277,000. The auction produced $118,000. The deficiency was $159,000 before costs. After the bank deducted its administrative fees, attorney costs, auction costs, and accrued interest that had been accumulating through the resolution process, the net deficiency, as calculated by First Wisconsin, was approximately $49,000 attributable to Ruth personally under the terms of the original loan agreements she had signed, in her own name, when the operating and mortgage debt was established. The registered letter contained a lawsuit. First Wisconsin Agricultural Credit versus Ruth Ann Pemberton. Claim for deficiency judgment in the amount of $49,000 plus costs. Ruth read it twice, then called the county extension office because it was the only agricultural office number she had in her address book. The extension agent referred her to a farm financial counseling service in Eau Claire. She drove there 2 days later. Foreclosure, in the common understanding of the word, means losing your property to the bank. In that sense, Ruth understood it correctly. She had lost the farm, the bank had taken it. What foreclosure does not mean, in the legal sense, is that the debt is extinguished along with the property. This is the distinction that most people in Ruth's situation do not understand until they receive a document like the one that arrived 6 weeks after the deed signing. When a lender forecloses on a mortgage, the process is essentially a forced sale of the collateral, the property that was pledged as security for the loan. The lender recovers whatever the collateral brings at sale. If that amount equals or exceeds the outstanding debt, the obligation is satisfied. The borrower owes nothing more. If the collateral sells for less than the outstanding debt, as it did in Wisconsin in 1987, as it did on hundreds of farm auctions across the Midwest during those years, the difference is called a deficiency. The deficiency is not forgiven by the foreclosure. It does not disappear because the property has been sold. The deficiency remains a personal obligation of the borrower, recoverable through a legal action called a deficiency judgment. A deficiency judgment is a court order requiring the borrower to pay the remaining debt from personal assets, savings, future income, personal property, anything that can be reached by a judgment creditor under state law. The land is gone, the obligation is not. The debt has moved from being secured, backed by real property collateral, to being unsecured, backed only by whatever the borrower has left. In Wisconsin in 1987, the law permitted deficiency judgments in mortgage foreclosure cases. The borrower had certain protections. The deficiency could not exceed the difference between the outstanding debt and the fair market value of the property at the time of foreclosure, regardless of what the auction actually brought. Ruth's attorneys would argue about what fair market value meant, given the distressed conditions of the 1987 auction market. But the legal mechanism, the bank's right to pursue the unpaid balance as a personal judgment, was not in dispute. Ruth had signed personal guarantees on the operating note and the mortgage. Her name was on the loan documents. The debt was hers. The farm had been the collateral. The collateral was gone. The debt was not. The counselor in Eau Claire asked Ruth one question that she had not considered. He asked whether she had been advised of her statutory right of redemption. Ruth did not know what that meant. In Wisconsin, at the time of the 1987 foreclosure, a mortgagor, the person who had pledged the land as security, retained the right to redeem the property after a foreclosure sale for a period of 6 months. During that redemption period, the original borrower could reclaim the property by paying the full amount of the outstanding debt, plus costs and interest. This right existed to protect borrowers from being permanently dispossessed of land that had value above the distressed auction price, and to give them time to arrange refinancing or a buyer at a better price. The counselor explained the practical implication of this right in Ruth's situation. The auction had produced $118,000 on a property with an outstanding debt of $277,000, or with a net deficiency of $49,000 on the portion Ruth was personally liable for. But if Ruth, during the 6-month redemption period, had found a buyer willing to pay $118,000 or more for the property, the same price the auction had produced, she could have completed that sale under the redemption right and used the proceeds to satisfy the same debt the bank was now pursuing. The deficiency would have been the same numerically, but her position in the transaction would have been different. She would have been the seller, not the debtor. Any amount above the outstanding obligation would have come to her. Any sale completed before the redemption period expired might have altered the deficiency calculation. She had not known the redemption period was running. The deed in lieu she had signed in March had not extinguished her redemption rights. Those rights attached to the mortgage, not to her voluntary cooperation with the bank. But she had not known they existed, and she had not been advised to explore them before signing. Her attorney at the deed signing had been a general practice lawyer handling what appeared to be a straightforward property transfer. He had focused on the transfer itself, not on what rights Ruth retained after it. The 6-month window was running from the date of the sheriff's sale. Ruth had the right to redeem. She had not known she had it. The counselor helped Ruth contact a farm debt attorney in Madison who had handled a number of deficiency cases during the farm crisis. That attorney examined the auction process, the deficiency calculation, and the applicable Wisconsin law. His argument focused on the fair market value question. Wisconsin's deficiency judgment statute did not allow a lender to collect the full gap between the auction price and the outstanding debt if the auction price was significantly below fair market value. The lender's deficiency was capped at the difference between the debt and the property's actual market value, not its distressed sale price. The attorney commissioned an independent appraisal of the Dunn County property as of the date of the sheriff's sale. The appraisal, based on comparable sales of operating dairy properties in the county, put market value at $148,000, substantially above the $118,000 auction price, reflecting the distressed bidding conditions rather than the land's actual value. If the $148,000 appraisal were accepted, the deficiency calculation changed. Outstanding debt, $277,000. Fair market value, $148,000. Maximum deficiency, $129,000. Against the portion of that deficiency attributable to Ruth personally, a reduced figure that the attorney calculated at approximately $22,000. The bank disputed the appraisal. Its own appraiser produced a lower value that aligned more closely with the auction outcome. The dispute went through a mediated review process that first Wisconsin and Ruth's attorney agreed to in lieu of full litigation. The mediation resolved at a personal deficiency figure of $31,000. The bank reduced its claim from $49,000. Ruth agreed to a payment plan, $500 per month over approximately 5 years. drawn from the income she was generating by taking a position as a milking hand on a neighboring dairy farm. The arrangement was not comfortable, but it was manageable. The redemption window had closed by the time the mediation concluded. No buyer had been found during the 6-month period. The right had expired unused, as it expired for most borrowers who did not know it existed. What happened to Ruth Pemberton in 1987 was not the result of any unusual circumstance. It was the standard legal consequence of a mortgage deficiency in a state that permitted deficiency judgments, applied to a property that sold at auction for less than the outstanding debt. It happened on farms across Wisconsin that year, and across the Midwest more broadly, wherever land auction prices had fallen below debt levels and wherever lenders had preserved their right to pursue the balance. The assumption that foreclosure ends the financial relationship between a borrower and a lender is a persistent misunderstanding. It ends the relationship between the lender and the land. The lender surrenders the collateral. It takes what the sale produces and applies it to the account. What it does not surrender, unless specifically agreed otherwise, is the right to collect any remaining balance from the borrower personally. Deed in lieu arrangements sometimes include a specific agreement from the lender not to pursue a deficiency, what attorneys call a release of personal liability or a full satisfaction clause. Some do not include this language. The agreement Ruth signed had included the phrase standard deficiency process, which her attorney had interpreted as a limitation on pursuit. The bank's attorney had interpreted it as a reservation of rights. The mediation ultimately resolved that ambiguity in a number that fell between the two positions. The redemption right is the mechanism that most borrowers in foreclosure never hear about, and the one that occasionally offers the most practical relief. A borrower who knows they have 6 months to find a buyer at or above the foreclosure sale price, and who can actually locate such a buyer in that window, can complete the sale themselves, retire the debt on better terms, and potentially avoid the deficiency that follows when the bank controls the sale. The right exists in most states. The window is finite. It requires someone to explain it before it expires. Ruth had not received that explanation. The barn on the Dunn County farm was eventually converted to cold storage for a local food cooperative. The milking equipment was scrapped. The 240 acres were farmed by the neighbor who bought them. Ruth worked on dairy farms in the county for the next decade, paying $500 a month toward a debt for a farm she no longer owned, on land she had farmed for 22 years. Foreclosure ended her ownership of the farm. It did not end the debt. Debt follows the person.